Dear learners, welcome back to your educational channel Learn and Educate. We were studying Code of Civil Procedure 1908, under which Part 8 Reference, Review and Revision, Section 115, Subsection 1. The High Court will call for the record of any case which has been decided by a court which is subordinate to such High Court and in which no appeal shall lie, if such subordinate courts appears if such an subordinate court appears to have exercised a jurisdiction not vested by it in the law. The High Court shall, for the record which has decided by a court which is subordinate to the High Court, then in which no appeal lies, and if subordinate court appears to have exercised a jurisdiction which is not vested in it by the law, that means that subordinate court does not have the power, does not have within its the jurisdiction to decide the case. Second, to have failed to exercise a jurisdiction so vested. And in part B, that subordinate court has not exercised the jurisdiction which were vested upon him. Third, to have acted in the exercise of its jurisdiction illegally or with material irregularity. When that subordinate court has acted materially irregularity and has used its jurisdiction illegally, then the High Court may make an order in the case as it thinks fit. Then the High Court shall, provided that the High Court shall not, under this section, that the High Court shall not vary the terms, shall not reverse any order which is made or the order which is deciding an issue in the course of the suit or in other proceedings, except where the order, if it has been made in the favor of the party applying for the revision, would have finally disposed of the suit or other proceedings, except when the order has been made in the favor of the party who has applied for the revision would have finally been disposed of the suit or other proceedings. The court, subsection 2, the High Court shall not under section 115 vary or reverse any decree or order against which an appeal lies, has been lied to the High Court or to any court which is subordinate to it. Third, subsection 3, a revision shall not operate as a stay of suit or other proceedings before the court except where such suit or other proceeding is stayed by the High Court, which means a revision shall not be operative for a stay of suit except when the High Court has made a stay on the proceedings of such revision. A High Court can only put a stay on the suit of such a revision proceedings. Otherwise, shall not operate as a stay of suit except when applied by the High Court. In this section, the expression any case which has been decided includes any order made or under deciding an issue in which the course of the suit or other proceedings. Section 115 states that under subsection 1, High Court may call for record of any case which has been decided by any court subordinate to such court and which no appeal lies thereto, and if such subordinate court appears to have exercised the jurisdiction not vested in it by the law, or such a subordinate court has failed to exercise the jurisdiction so vested, or such subordinate court have acted in the exercise of its jurisdiction illegally or with material irregularity, then the High Court may make such order in the case as it thinks fit. The High Court may make such order in the case as it thinks fit, provided that the High Court shall not, under this section, vary or reverse any order made or any order deciding an issue in the course of a suit or other proceedings, except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceedings. Subsection 2. The High Court shall not under this section vary or reverse any decree or order against which an appeal lies either to the High Court or to any court subordinate thereto,